Let me do that again. There we go. Hey, good morning, everybody. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, April 12th, 2023. The time is 9:30 a.m. I'm joined today by Commissioner Emily Lindley and our General Counsel, Mary Smith. Commissioner Janeka is on his way. I understand he'll be here shortly. And I'm John Neerman. For those who are joining us virtually, I'd ask you to please keep your microphones muted when you're not speaking. For those who are making presentations, please wait to begin your presentation until our General Counsel or I have asked you to begin speaking. On items where argument or discussion is allowed, we will inform speakers of their time limits. Registration has now closed, but if you'd like to address the Commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item that you'd like to speak to, and we will do our best to accommodate your request. And with that, I'd like to thank everybody for being present. And Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the application of Crystal Springs Water Company Incorporated for Texas Pollutant Discharge Elimination System permit number WQ00160050001. The order of presentation should begin with the applicant, followed by the protestants, the ED, and OPIC. The parties will each have 5 minutes of oral argument time. The applicant may save time for rebuttal as it bears the burden of proof on the application. I believe we have Ms. Marissa Chambers here for the applicant.
Good morning, Ms. Chambers.
Good morning, Chairman Neerman and Commissioner Lindley, and Janeka when he gets here. I'm Maris Chambers. I'm an attorney at Spencer Fane here in Austin, and I'm pleased to be before you today on behalf of my client, Crystal Springs Water Company, the applicant in this proceeding. Crystal Springs appreciates the opportunity to speak with you today, but I don't intend on taking up too much of your time because we support the recommendation in the proposal for decision before you. Essentially, that proposal for decision recommends that the draft permit prepared by the executive director's staff be issued without alteration. Could everyone hear me?
There we go.
Should I start over?
I think we've got you.
Okay.
Yeah, thank you.
So I was saying Crystal Springs believes that the recommendation of the administrative law judge that you all issue the draft permit without alteration is the right one. The draft permit complies with all applicable statutes and regulations, and we hope that you will issue it this morning. With that, I'd like to reserve the remainder of my time for any questions you may have or rebuttal should it become necessary. But
All right.
Thank you.
Thank you, Ms. Chambers. Commissioner Lindley, any questions? All right. Let's hear next from the protestants. Is there Mr. Leitke or Mr. Budd present?
They didn't sign in, so
Okay, well,
I'm
let's do
guessing
this.
they're
Let's,
not here.
just in case they're trying to log in virtually, we'll come back to them again. But next up would be the Executive Director staff. Good morning.
Good morning, Chairman. Good morning, Commissioners, General Counsel, Public Interest Counsel. My name is Cole Malley from the Environmental Law Division. With me today is Feroz Vahora from the Water Quality Division. The ED staff reviewed the Crystal Springs application for new TPDS permit number WQ00160050001 and drafted a permit based on that application that will protect human health and the environment. The ED supports the ALJ's conclusions and recommends that the Commission grant the application and issue the draft permit. Thank you.
Thank you, Mr. Malley. Any questions? All right. We'll hear next from the Office of Public Interest Counsel. Good morning, Ms. Mehta.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Director's attorney and staff. I'm Pranjal Mehta for the Office of Public Interest Counsel. At this time, OPIC supports the Administrative Law Judge's proposal for decision on summary disposition. When the unrepresented protestants late filed a witness list and exhibits, including 15 photographs and maps, OPIC took the position that protestants had done just enough to avoid summary disposition. However, since that time, protestants have done nothing more to meet their burden of production and rebut prima facie demonstration provided to applicant by the administrative record. Also, the protestants did not appear at any pre-hearing conferences and did not file any response to applicant's motion for summary disposition. Considering the totality of the record, OPIC must now agree with the ALJ's analysis and recommendation. For these reasons, OPIC respectfully recommends adopting the ALJ's proposed order and issuing the permit. Thank you, and I'm happy to answer any questions.
Thank you, Ms. Mehta. I have none. Any questions, colleagues? All right. Ms. Chambers, would you like to offer anything in rebuttal to that?
No, sir.
Okay, thank you. Colleagues, as you know, under the Texas Government Code, the filing of the administrative record on this item established a prima facie demonstration that the application meets all state and federal requirements. The protestants, as we heard, did have opportunities to rebut this presumption, but they presented no evidence. The ALJ therefore found that there's no genuine issue of material fact and recommends issuance of the draft permit. I certainly agree with that, but I would propose two changes to the findings of fact. Beginning with number 10, I would restate finding of fact 10, which relates to the Tier 2 review, simply to more closely adhere to the language in our rules at 30 Texas Administrative Code, Section 307.5. And with respect to finding of fact 20, there were 2 referred issues, not 8 issues. So if it's all right with you, I think I'll go ahead and offer a motion to that effect, and we can discuss it on the other side.
Sounds good.
All right. Colleagues, I move that we adopt the ALJ's proposed order with the following changes. Revise finding of fact number 10 to state, quote, a Tier 2 anti-degradation review has preliminarily determined that water quality will not be lowered by more than a de minimis extent in Caney Creek, which has been identified as having high aquatic life use, and that existing uses will be maintained and protected, end quote, to be consistent with the language used at 30 Texas Administrative Code, Section 307.5. And I further, and the next change would be to amend finding of fact number 20 to replace the number 8 with the number 2 to reflect the correct number of issues that were referred to SOA in this matter. I would further move that we issue the executive director's draft permit, and finally that we adopt the executive director's response to comments.
A second.
All right, the motion has been made and seconded. All those in favor say aye.
Aye.
Aye. Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 2 is the consideration of whether to affirm, modify, or set aside the executive director's emergency order renewing the appointment of a temporary manager of the water utility abandoned by Linda Royal, Robert Watts, Peggy Parlin, Mitchell Watts, and Shane Watts. The ED is the moving party and should speak first, followed by the respondents, any other interested persons, the temporary manager, and OPIC. Each party will have 5 minutes to address the commission. The ED may save time for rebuttal as she bears burden of proof on this matter.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Benjamin Worms, and I'm an attorney with the Litigation Division representing the Executive Director. With me today is Dorothy Young of the Water Supply Division, and we're joined online by Joy Thurston Cook of the San Antonio Regional Office. Item number 2 is the emergency order renewing the appointment of a temporary manager for the utility previously owned by Alan Watts. The utility was owned by Alan Watts from 1997 until his death in October of 2021. At the time of Mr. Watts' death, the utility was being operated by Paul and Linda Royal, who had assumed operation of the utility when Mr. Watts became too ill to operate himself. The Royals continued operation of the utility after Mr. Watts died. Mr. Watts died intestate without transferring ownership of the utility, and his estate has not been probated. The named respondents in this emergency order are the children of Alan Watts, who are the known heirs to the estate of Alan Watts under Texas intestate succession. On June 13th, 2022, an attorney for the Royals sent a letter to the staff of TCEQ, the Public Utility Commission, and the Office of the Attorney General, stating that the Royals would cease operating the utility effective June 20th, 2022. The Royals did continue to operate the utility after this date, but then on June 1st, 2022, Paul and Linda Royal sent a letter to staff of TCEQ, the Public Utility Commission, and the Office of the Attorney General, stating that they would stop operating the facility on September 1st, 2022. Given this second notice from the Royals, the utility was determined to be abandoned, creating a substantial risk of imminent water outages and posing health hazards to the customers served by the utility. Because of this, the executive director issued an emergency order on September 1st, 2022, appointing Bill Shuley as the temporary manager for an initial term of 180 days. Mr. Shuley is the wastewater manager for the city of Luling and a licensed water operator. He is managing the utility on behalf of the city of Luling. During the first temporary management term, continuous and adequate service has been provided to the customers of the utility, and progress has been made in both engineering and securing funding to provide a long-term solution to the customers. Mr. Shuley's first term as temporary manager expired on February 28, 2023, and on March 1st, 2023, the executive director issued an emergency order renewing the appointment of Mr. Shuley as temporary manager for an additional 180 days. The executive director respectfully requests that you affirm the March 1st, 2023 emergency order, and we are available to answer any questions you may have.
Thank you, Mr. Worms. I have none. Colleagues, any questions?
No, thank you.
All right. Is there anyone here for the respondents? Any of the Watts family members or the Royals? Or anyone online? All right. Hearing none, is anybody signed in to speak?
No one was signed in,
Okay.
and no interested persons were signed in either.
Okay. And then if Mr. Shuley is with us and would like to address us, this would be your opportunity. Okay. Let's turn to OPIC. Good morning.
Hey, good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne with the Office of Public Interest Counsel. We've reviewed this item, and we agree with the Executive Director that the requirements for an emergency order contained in Chapters 5 and 13 of the Texas Water Code have been met, and that the issuance of the emergency order was appropriate. Therefore, OPIC supports affirmation of the March 1st, 2023 emergency order. Thank you, and I'm certainly happy to answer any questions that you may have.
Thank you, Mr. Wayne. I have none.
No questions.
Seeing none. Well, let me begin by thanking Mr. Shuley for taking this on and for his willingness to continue serving the system. Colleagues, this system very clearly needs his continued service, so I'm in favor of affirming this order.
As am I. Sorry, but
Likewise, my understanding in terms of where the speed of how quickly our agency can act on this, or whether it's even necessary, whether it would bring quicker relief or not by referral to the Attorney General's office, those considerations are eclipsed by the nature of the ownership of this facility. And I think until that's able to move through whatever the process is, be it probate or whatever, our agency wouldn't necessarily be able to take other quicker appropriate steps. But I think this is always an issue that I appreciate the Executive Director's expertise on. These regulated facilities in our state that provide public water to the customers of Texas always offer a really delicate balance for us to try to support and both hold to the high standards that they're kept to. But I appreciate Mr. Shuley's efforts again, so thank you, Chairman.
Thank you, Commissioner. Do we have a motion?
I move that we affirm the Executive Director's emergency order reappointing a temporary manager of the water utility formerly owned by Alan Watts, located at 114 Salt Lake Road, Luling, Guadalupe County, and issue the ED's proposed commission order.
a second.
The motion has been made and seconded. All those in favor say aye.
Aye.
Motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 3 is the application by GCC Sun City Materials LLC for renewal of TPDS permit number WQ00046360000. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So for the benefit of those who are not familiar with our process, Chapter 55 of our rules provides a two-part analysis for considering requests for contested cases on TIPD's applications. First, we consider whether the requesters have met the procedural and substantive requirements to be entitled to a contested case, and assuming that at least one has done so, we then consider which issues are appropriate to refer for hearing. So part one is about who gets a hearing, and part two is about which issues are referred. Requesters who are affected in a manner different from the general public and who make timely comments articulating personal concerns that are relevant and material to the application and who express those concerns in a timely hearing request are entitled to a hearing. And colleagues, on this item, we have a single request from Hudspeth County Commissioner Sheets. I want to point out that the county itself has not requested a hearing, and so we will analyze Commissioner Sheets' request as an individual request rather than as a governmental entity request. Some of the concerns that Mr. Sheets expressed are certainly within TCEQ's jurisdiction on this application. In other words, they're relevant material. However, given the distance of his residence to the subject monofill, he does not, in my view, identify an interest that is distinguishable from the general public. So I believe we are required to deny this request. The commissioners also filed a request for reconsideration, but I believe the concerns that he's raised there have been adequately addressed in the executive director's response to comments, and that they would not alter that decision, so I would deny the request for reconsideration as well. Commissioner Lindley, how do you see it?
Came down the same way.
Commissioner Janeka?
Well said, I'm in agreement.
I can offer a motion if we're ready.
Great.
I would move that we deny the hearing request and request for reconsideration for Hudspeth County Commissioner Johnny Sheets, issue the renewal of Texas Pollutant Discharge Elimination System permit number WQ00046360000 to GCC Sun City Materials LLC as recommended by the Executive Director and adopt the Executive Director's response to comments.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, please call the next item.
Item number 4 is the application by Green Raindrops Incorporated for new TPDES permit number WQ00160890001. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
So again, we have a two-part analysis under Chapter 55. Part 1 is about who gets a hearing. Part 2 is about which issues are referred. And again, requesters who are affected in a manner different from the general public and who make timely requests articulating personal concerns that are within our jurisdiction on the application and who express those concerns in a timely hearing request are entitled to a hearing. We have a single request on this item as well, colleagues. Mr. Collins, he has raised several issues about potential impacts from water contamination. He lives very near the proposed facility. I think he has identified personal concerns different from those of the general public, and so I would grant his request on the following issues: whether the draft permit complies with the Texas Surface Water Quality Standards and other applicable rules, whether it is protective of both water quality and the existing uses of the receiving waters, whether it is protective of aquatic life and wildlife, whether it complies with siting requirements, and finally, whether it contains adequate monitoring, record keeping, and reporting requirements. And I would also suggest that we allow the full 180 days on this hearing and issue a concurrent referral for alternate dispute resolution.
I'm in a complete agreement.
Likewise. And I will attempt a motion on that. I apologize in advance if I'm coughing. It's not COVID, but Still there. I move that we grant the hearing request of Ricky Collins, refer the application to SOA for a contested case hearing on the following issues. Issue 1, whether the draft permit is adequately protective of water quality in the receiving waters, including the protection of designated uses and aquatic life and wildlife, in accordance with applicable regulations, including the Texas Surface Water Quality Standards. Issue 2, whether the draft permit complies with applicable siting requirements in 30 TAC Chapter 309. And Issue 3, whether the draft permit contains adequate monitoring, record-keeping, and reporting requirements to ensure compliance with permit terms. I further move that we refer the matter to the Commission's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts and set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 5 is the application by Harris County Municipal Utility District number 171 for a major amendment with renewal of TPDS permit number WQ 001-526-4001. The parties have been notified that the commission will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, colleagues, once again, we have our two-part analysis under Chapter 55, similar to the last two items. And we have 3 requests on this particular item. All 3 raise concerns that are within our jurisdiction on this application, and all of the parties live within 2/3 of a mile of the facility. So I agree with the executive director and OPIC that we should grant a hearing on all 3 requests. Any disagreement with that first step? All right, seeing none, I would refer the following issues: whether the draft permit is protective of the health of the requesters and their families, whether it is protective of water quality, including protection of surface and groundwaters, as well as aquatic life, wildlife, and livestock, and whether the draft permit adequately addresses nuisance odors under 30 TAC Section 309.13. And again, I would allow the full 180 days on this hearing and include an ADR referral.
I would agree. I think you might have said this, but if not, the only thing I would add is that we deny the request for reconsideration. And you might have mentioned that, and I apologize.
I did not,
Okay.
but yeah, thank you for catching that. I agree with that.
Yeah, otherwise I'm in agreement.
Commissioner Janeka?
Okay,
All right.
Likewise.
I'll attempt a motion then. I move that we grant the hearing requests of James Donnelly, Christopher and Donisha Spicer, and Gregory Johnston, that we deny all the requests for reconsideration, that we refer the matter to the TCEQ's Alternative Dispute Resolution Program to run concurrently with SOA preliminary hearing scheduling efforts, and that we refer the application to SOA for a contested case hearing on the following issues. 1, whether the draft permit is adequately protective of the requesters and their families' health in accordance with applicable regulations, including the Texas Surface Water Quality Standards. 2, whether the draft permit is adequately protective of water quality in the receiving waters, including the protection of surface water, groundwater, aquatic life, livestock, and wildlife in accordance with applicable regulations, including the Texas Surface Water Quality Standards. And 3, whether the draft permit adequately addresses nuisance odor in accordance with 30 TAC 309.13. And that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 6 is the consideration of a resolution to appoint 3 members to serve on the Irrigator Advisory Council. The executive director's staff is here to present this item.
Good morning.
Good morning. Good morning, Commissioners, General Counsel, Public Interest Counsel. For the record, I'm Melissa Keller, Special Assistant to the Deputy Director of the Program Support and Environmental Assistance Division.
With me today is Alicia Ramirez, Staff Attorney with Environmental Law Division. We are here today to request the appointment of 3 members to the agency's Irrigator Advisory Council. If appointed, these recommended appointees will receive 6-year terms that expire February 1st, 2029. The recommended appointees are Donald D.J. Seeger, irrigator from Canyon Lake, Mr. Norman Werbach, irrigator from Corinth, and Ms. Monique Cogburn, public member from San Antonio. Included in your backup material are resumes for each of the recommended appointees describing their backgrounds and qualifications for the appointments. We are available to answer any questions you may have on this matter.
Thank you, Ms. Keller. I have none. Colleagues, any questions?
No, thanks.
All right, seeing none. Ms. Smith, is anybody signed in to speak?
No one signed in.
And OPIC, Mr. Arthur, good morning. What say you?
Good morning, Chairman and Commissioners. For the record, I'm Garrett Arthur, TCQ Public Interest Counsel. OPIC supports approval of the resolution as recommended by the ED.
Thank you. I do too, colleagues. I think the executive director has made some good recommendations here. I want to thank the nominees and the members for their service. I'm ready to move forward with the resolution.
As am I.
Well said. And thanks to those nominees for agreeing to serve, as well as the other existing members of the council continuing to help our agency. I move that we adopt the executive director's recommended resolution filling the vacancies on the Irrigator Advisory Council, appointing Monique Cogburn, Norman Werbach, and Donald D.J. Seeger, each for a 6-year term effective April 12, 2023 through February 1, 2029.
I second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
That takes us to our enforcement docket, which are items 7 through 9 and 11 through 22. The executive director's staff is here to present the matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Michael Parrish, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 7 through 9 and 11 through 22. The total assessed administrative penalties are $353,201, with $77,549 deferred, $154,950 applied toward supplemental environmental projects, and $120,702 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Colleagues, any questions?
No, thank you.
Seeing none. Ms. Smith, is anybody signed in wishing to speak?
On items 9, 13, and 19, we have individuals who have signed in and indicated that they're available for questions, and their presence will be noted for the record.
Thank you. Mr. Arthur?
OPIC supports adoption of these enforcement orders as presented by ED staff.
Thank you. Colleagues, I'm ready to move forward with this item.
As am I. I would move that we adopt items 7 through 9 and 11 through 22 as recommended by the executive director.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 23 is the consideration for adoption of a proposed revisions of 30 Texas Administrative Code, Chapter 7, a memoranda of understanding. The executive director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Kathy Humphreys of the Environmental Law Division. The rulemaking was in response to the quadrennial review where the Commission determined that 30 TIC 7.101, the MOU with the Texas Department of Commerce, is obsolete. Section D of the rule provides that the memorandum shall terminate on August 31st, 1999, unless extended by mutual agreement. The TNRCC and the Texas Department of Commerce did not extend the term of the MOU. Notice of the proposed repeal was published in the November 4th, 2022 issue of the Texas Register. No comments were submitted. The Executive Director respectfully recommends the adoption of the repeal of the obsolete rule. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, and I'm available for questions.
Thank you, Ms. Humphries. I have none. Colleagues, any questions?
No, thanks.
Ms. Smith, is anybody signed in to speak?
No.
Mr. Arthur?
OPIC agrees that 30 THC Section 7.101 is now obsolete and should be repealed. We support adoption of this revision.
Thank you. Colleagues, before us is an MOU that is both obsolete and it has expired, long since expired by its own terms. So I'm going to go out on a limb here, and I will move that we approve the adoption of revisions to 30 Texas Administrative Code, Chapter 7, Memoranda of Understanding as recommended by the Executive Director.
I'll second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Ms. Smith, when you're ready, please call the next item.
Item number 24 is our public comment session. We currently don't have anyone signed in to speak, but we can pause here and wait to see if anybody wants to speak.
Is there anybody who's joined us virtually who would like to comment? All right, hearing none, and I don't see anybody headed for the podium, so Ms. Smith, I'll ask you to call the next items.
Items 25 through 28 are for closed session, and the commission will meet in closed session in Building E, Room 211S at, I'm going to say 10:05?
Sure.
Approximately 10:05, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items 25 through 28 as posted and noticed.
The time is 10:02 a.m. We are in recess.
The commission met in room 211S of Building E for closed session from 10:05 until 10:37 a.m. on items 26 through 28 as posted in notice pursuant to Texas Government Code, Section 551.074. No action was taken. The agenda stands adjourned. The time is 10:47.